Mr. Abiodun Owonikoko, Senior Advocate of Nigeria, joins us next to give us some perspectives on some of these matters. Good morning and thank you for joining us today. Well, so many things are confusing to laymen about law, and maybe Nigerian law, because sometimes what you read is not what it is, as it turns out. First, could you explain to us the implication of the letter that was written by the Attorney General of the Federation to the IGP, asking him to provide security cover for the members, I think 17 members, who have supporting the APC candidate to go to the House for legislative purposes, when some argue that, wait a minute, that shouldn't be. What's the position of the law on that?
Thank you. I think under certain circumstances, there is a federal preemptive powers that allows the authority at the federal level to interfere in the affairs of a state government. And such instances will be those where, by resolution of the relevant members of the House of Reps, it is determined that the state House of Assembly can no longer conduct its affairs. The other instance is where the governor or the president apprehends a state of emergency within that state that warrants intervention of the federal executive authority. In both of these instances, the Attorney General of the Federation has no role to play at all. Now, with regards to a sitting parliament at the state level, it is incongruous that 1.5 years after a new parliament has been inaugurated, the AG of the Federation will be writing letter on behalf of members elect, not members of parliament, but members elect, at a time when, even if they were properly sworn in, their abstention from proceedings and sitting of parliament for more than 181 days will render them liable to have their seats declared vacant. Next is that issues surrounding the manner in which the parliament in Edo State was inaugurated are subject of at least 3 pending litigations, one of which was conducted by a high court in Port Harcourt, in which a judgment has been given finally, and the aggrieved parties are on appeal at the Court of Appeal. That judgment is to the effect that the governor of the state had no power to issue proclamation for inauguration of parliamentary sitting more than once during a tenure. That has been done, rightly or wrongly, and the aggrieved parties have gone to court. With these cases pending in court, it is very strange and disturbing that a letter will be issued by just a legal practitioner on the 3rd of August. And the Attorney General of the Federation will purport to act on that on behalf of that lawyer's clients, directing the Inspector General of Police to interpose and force those people into the premises of Parliament and assist them to conduct affairs. One, the confirmation that those are members elect is the very reason they cannot participate in parliamentary affairs until they have been sworn in. It's a different thing if members of parliament duly sworn in are being prevented right of ingress and egress out of parliament. So it is strange and very, very worrisome that such a letter should be issued, especially at this critical time.
So what is the IGP expected to do about this letter now? Is he supposed to obey it and provide security cover? What should he do?
Now, under the 1999 Constitution, both the Attorney General, IG, Governor, President are all obliged and obligated to respect and give effect to judgments of courts. As at the time the letter from the AG was issued and addressed to the IG, a judgment of court had already ruled and validated the inauguration of Edo State House of Assembly. It was therefore not in consonance with the Constitution, rule of law, and due process, as well as respect for state autonomy, for either the AG or the IG to purport to be acting on their own internal communication to interpose themselves in the affairs of a state House of Assembly. Let me make this clear. The AG Federation has no role whatsoever to play in the internal workings of a state House of Assembly. If there are legal issues there, the right person to approach for legal advice within the state is the AG of the state. It is not AG Federation. And if the AG of the state gives an opinion that either party does not agree with, the next recourse is to go to court. But we have even already passed that stage because the parties are already in 3 different courts. Court of Appeal in Port Harcourt, High Court in Edo, and Federal High Court in Abuja. So the matter is sub judice, and I do not see how we can reinvent a course of action from a case that is already ongoing in court. It is very unfortunate.
Okay. And
it portends ill for the coming election in the state.
Well, Mr. Owonikoko, is that saying that the AGF acted illegally?
Oh, definitely. I don't want to mince words about it. And I'm sure the AG himself in his good conscience knows that. What has he been doing since June 2019 when the Edo State House of Assembly was inaugurated? What was he doing when those cases were pending? As AG that is proactive, he should actually, if he felt he had an issue, should have sought to be heard in those matters. He has a right as the AG Federation by related action to say, the AG Federation considered this to be a matter of constitutional importance. I would like my office to be heard in this matter. That is the only recourse. Even if he wasn't joined, he could have sought audience, and by law, the court.
Okay, well, we're just trying to, well, yeah, sometimes this technology can just fail you at that point in time, but he's talking about that letter that was written by the AGF to the IGP of police. But then next is you just wonder, now, one, the letter has been written, and the members are saying that, look, whether or not these other members have a right to declare their seats vacant, because they just felt that, no, the proclamation, much as it might have been, but there are contentious issues. But let's see if we'll have him back and put that question to him. Do we have him back now, gentlemen? Okay, Mr. Owonikoko, now, about declaration of seats vacant, what is the procedure? Because different groups, both of them are saying, look, we are in the right first to have declared seat vacant. Others say, no, we have inaugurated the member because we have majority. What is the correct position?
There is no thing like majority outside of parliament. Majority of the House, except for where there is constitutional threshold, is the 1/3 of members present and sitting at any proceeding. 1/3 of Edo State House of Assembly, which is 24, should be 8. And as far as I can recall, as at the time the parliament was inaugurated, usually not by governor, and people are misunderstanding this issue. It is not a governor that inaugurates parliament. When they are first elected, the clerk of the house is the one that conducts the election of the first leaders of the speaker and deputy speaker. After the speaker and deputy have been elected under supervision by the clerk, the speaker then swears in all members present. So where does the governor play a role in all of this? His duty is to issue a proclamation for parliament to sit. And after that has been done, it will be remiss of the governor to begin to influence or direct the affairs of parliament. If that were to be the case, then that would be an impeachable offense because it would be exceeding his own remit as the head of the executive arm trying to hijack the legislative arm of government. So anybody today, if you look at the AG's letter, it refers to them as members elect. You can't be a members elect more than 1 year after you have been elected.
Okay, so we'll come back to this. We'll let you shed some more light on that particular point, the duration for which you can be a member of elect for. Just hold on a minute. We'll be back. Welcome back. Mr. Owonikoko, so tell us, how long does the law permit one to be a member-elect for? And after that, what happens to the seats?
Yes. Now, for the purpose of membership of parliament, where you have been duly elected, in fact, the Electoral Act provides that failure of INEC to issue you with a certificate of return after 7 days dispenses with that certificate of return, and you are entitled as of right to be sworn in once you present yourself. So the maximum period a person should remain member-elect, pending absence of any court order to the contrary, is 7 days after you have been elected and parliament has been proclaimed. Now, for that purpose, if you choose not to be present at the inaugural sitting of parliament, you only take whatever is left of your tenure at the time you present yourself for swearing in. But that means you must be available so as not to have been absent for half of the sitting for a whole year, which is 181 days. That's the minimum sitting requirement for you to be in parliament. If you fail to make that minimum, if you fail to sit for up to that period of time, it is the prerogative of parliament to declare your seat vacant. I am aware, I'm not going to say whether that is right or wrong, that seats of these gentlemen have been declared vacant by the speaker as then concerned. Now, let me read to you what section 102 of the Constitution says. A House of Assembly may act notwithstanding any vacancy in its membership, and the presence or participation of any person not entitled to be present at or to participate in the proceedings of the House shall not invalidate such proceedings. Now, Parliament, House of Assembly's quorum is 1/3. From the period of inauguration, 17th of June 2019, I'm not aware that Parliament of Edo State has been unable to form a quorum. So all what they have done, including speakership appointment, which election of speaker, which is not normally done by the parliament, but conducted by the clerk of the House, and then subsequent swearing of all members present, I'm not aware that that has been validated. So the fact that some people chose to absent themselves from that swearing, which is also part of our lack of respect for due process, and they went to converse somewhere, is a reminder of the mistake that APC made in 2015 that led to the emergence of non-endorsed party candidates as Senate President and Speaker. You remember what happened? Some members of party, out of party loyalty, went to converge at International Conference Center. Meanwhile, Parliament has been proclaimed and sitting was going on.
Can I just add this before we wrap up?
Appointment.
Yes. Yeah, so
thank you.
What happens, what is the provision of the law? Because they argue that no, not that we absented ourselves, there were circumstances, they did it in the dead of the night, it wasn't properly done. Does the law cover or protect such persons where a group, assuming that was the case, were deliberately trying not to get them sworn in?
Well, I think they will have a point if indeed, because the proclamation usually should state the date of proclamation, that Parliament shall start sitting on a particular day. And I think if the proceedings were conducted outside of the sitting hours of Parliament by their own rules, that would be a cause for those who are aggrieved to go to court, not to go and say, Attorney General of Federation and IG, come and enforce a right that no court has affirmed. I've told you today, rightly or wrongly, a court has affirmed that proclamation. The argument they may have will be against the clerk of the House. They should have sued the clerk of the House for conducting proceedings, that inaugural proceedings, at allegedly odd hours. Because there is a working hour, and Parliament can extend working hours. So an official working day starts by Nigerian law at 7:30, and I think it was moved to 8 o'clock. So sit earlier than that. There has to be a decision. But
all right, apologies. We just need to wrap it up there. But we do thank you very much indeed for your thoughts there, Mr. Abiodun Owonikoko, Senior Advocate of Nigeria. Always a pleasure to have you on.
My pleasure too.